Harani Law Circle மாணவர்கள் அனைவருக்கும் வணக்கம். I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 13 of our target to complete 50,000 multiple choice questions in law. If you haven't seen our previous 12 parts, I request you to visit our channel's playlist or check out for the links in the description box. These 50,000 multiple choice questions will help you crack any legal examination which is conducted in your state or in a national level, be it the civil judge exam conducted by Tnpsc, special legal officer conducted by various departments in India, judicial services exam, or even the district judge examination, you'll have the confidence to put your 100% in the performance. These 50,000 questions are divided into 1,000 parts to make it easy and comfortable for you in your preparation. The team has also planned for a mains-based descriptive question series where we will be covering 1,000 mains-based descriptive questions and answers with the explanation. I will be explaining each of the questions to you. So in that way, you will have the confidence to clear the mains as well. And there are senior advocates who will be interviewing students. So you'll have a grasp of how the interview goes in the judge exam. So in that way, a comprehensive coverage of prelims, mains, and interview will be covered in our channel. So this is provided to you completely free of cost. And you know that there is multiple struggle which is undertaken by our team to conduct these sessions free of cost. So each of these PPTs need to be thoroughly prepared without any mistakes. And the explanation part needs to be drafted in such a way to get more marks in the examination. So for all these struggle which we undertake to provide you the best out of law, the only favor that we request from you is I want you all to share this session or our upcoming sessions to your friends, juniors, and if there is any professor who is watching this session, to your students as well. And to the students and juniors who are not able to afford for a proper coaching or to join a proper mock test. In that way, it will benefit a larger community. So without wasting much of a further time, let's pop into the first question of our session. So the questions will be framed to you in English as you can see on the screen. And the answer to these questions will also be on the screen in bold letters. So you don't confuse yourself with the answer. And the explanations to each of these questions will be displayed to you in the subsequent slide. So if you're not clear with the explanation which I give, it will be clear. But in case if you want to have more clarity or if you feel there is some ambiguity, just refresh my explanation and watch it, or you can just read out this explanation to get a better clarity and then move to the next question. So the first question of the session. The amendment of the Transfer of Property Act 1882 in the year 2002 amended the provisions of Section 100, Section 106, 108, 110. I read the options because we already know what is the answer, but the reason behind reading options is we need to understand why the option is wrong. There might be questions where you need to choose correct and incorrect options. So obviously, we need to read all the options to get a better clarity. You might come across the same question in the examination. Section 106 is the answer. So what does Section 106 amendment deal about? So 106 is basically about the duration and termination of leases, where in case of an agricultural or a manufacturing process, so the termination of lease is 6 months, 6 months of notice. And if it is any other process other than the agricultural or manufacturing process, it is 15 days notice. So this is the amendment that was undertaken in 2002 regarding 106th TPA. So if you don't have a clarity on the explanation, just go through each and every point in the explanation, then you'll have a better understanding. Second question. No right of action is conferred on a transferee in possession under an unregistered contract of sale. Which section of the Transfer of Property Act 1882 contains this principle? Section 35, Section 41, Section 53, Section 53A. We all know that in our previous sessions, we have seen that Section 53A is with respect to part performance of contract. So part performance of contracts are basically of defensive of nature. So we usually call it this particular section 53A is a shield and not a sword. So we know that shield is a defense and sword is the right that we have, a legal right that we have against the contracting other party, right? So section 53A is about part performance, where a part of the contract is performed and the other part is not yet performed in a sale, in a contract of sale, wherein the legal right is not particularly available with respect to the contract, but there is only a chance of defense that we can take in case there is a dispute. So in Srimant Shamrao Survanshi versus Prahlad Bairabo Survanshi, which is a 2002 case, the Supreme Court held that Section 53A confers a right of defense but not an independent right of action or title. Moving ahead to the third question. Section 115 of the Civil Procedure Code provides provisions for the following: reference, review, revision, appeal to the Supreme Court. So what section 115 of CPC says is that the court, High Court, can basically call for records of cases which are in the subordinate courts, wherein there are certain irregularities or the subordinate court is not competent to adjudicate such cases. So in such circumstances, the High Court may call for the record of any case which has been decided by a court which is subordinate to it. For example, a city civil court or any other district court, and in which no appeal shall lie. And the subordinate court which appears to have exercised jurisdiction not vested in it by law, or the subordinate court should have failed to exercise jurisdiction vested in it, or it should have acted illegally or with material irregularity in exercising jurisdiction. So in those cases, the High Court may revise the particular decision taken by the subordinate court. Okay. So the judicial precedent with respect to this case is Shiv Shakti Corporation Housing Society versus Swaraj Developers, which was a 2003 case where the Supreme Court held that the object of section 115 to prevent subordinate courts from acting arbitrarily, capriciously, or illegally in the exercise of their jurisdiction. So 115 is with respect to revisional jurisdiction. Fourth question. Judgment under section 2 subsection 9 of the Code of Civil Procedure 1908 means a decree, dismissal of appeal summarily, statement of grounds of a decree or order, all the above. So decree has a separate definition under the Code of Civil Procedure. So a decree cannot be an answer for judgment. Dismissal of appeal summarily. So does all judgments basically say about dismissal? No, right? There are judgments which give legal opinions. They give obiter dicta. So in such circumstances, it cannot be dismissal of appeal alone. Statement of grounds of an order or decree. So option C is the correct answer to this question. So let's look at the explanation. Section 2, subsection 9 of Code of Civil Procedure defines the term judgment, where it says judgment means the statement given by the judge on the grounds of a decree or order. So a judgment is not same as of that of a decree. So it is more elaborate and wide in nature. Just pause and read the complete explanation and then move to the next question. It is not a big problem for you in understanding these explanations. Next question. Reservation of seats in educational instructions in favor of scheduled castes and scheduled tribes is governed by. So the correct answer is Article 15, Clause 4 of the Constitution. So Article 15, Clause 4 of the Constitution was inserted by the First Amendment 1951. It was to enable to make special provisions for the advancement of socially and educationally backward classes. So we usually call it SEBC, which includes scheduled castes and scheduled tribes. Wherein Article 14 Article 14 deals about equality, and Article 15 gives special provisions which mention that nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially educationally backward classes of citizens or for the scheduled castes and scheduled tribes. So this interpretation was held in State of Madras versus Champakam Dorairajan, which was a 1951 based case. So it is a landmark decision based on caste based reservations, which was struck down in educational institutions as unconstitutional. Moving ahead to the sixth question. Rajya Sabha can withhold a money bill for a period of 14 days, 3 months, 6 months, none of the above. So money bill is a bill which can be passed only in a motion for money bill can be passed only in the Lok Sabha, where it is referred to the Rajya Sabha. So within 14 days, the Rajya Sabha should recommend any objections or any amendments or any alterations. And if the Lok Sabha passes it again without any alterations or amendments also, then it has to approve. So the Rajya Sabha can hold a money bill for a period of only 14 days. So if it holds it more than 14 days, it is deemed that the money bill is already passed. After 14 days, the money bill automatically gets passed by the Rajya Sabha. Seventh question. The power of judicial review in India is possessed by Supreme Court alone, by all courts, Supreme Court as well as High Courts, none of the courts. So the power to judicial review is available to both the courts, Supreme Court and the High Court. So the judicial review is basically the power of courts to examine the constitutionality of legislative and executive actions. If any law or executive action is found to be violative of the constitution, it can be declared null and void. With respect to India, Supreme Court and the High Court under Article 32 and Article 226, which are commonly known as writ jurisdictions, they have the power of judicial review. Article 13, Clause 2, it says any law that violates fundamental rights is void. So the legislature cannot enact any law which is violative of the fundamental rights under the Constitution of India. So the judiciary can review such legislative action or executive action. Even executive actions can be held by judicial review's decision. Moving ahead to the eighth question. Which of the following statements regarding consideration is not correct? It must be given at the desire of the promiser. It may be passed. It need not be adequate to the promise. Stranger to it cannot sue. So read the question carefully, or otherwise you might go wrong. So the correct answer is stranger to it cannot sue. But usually this stranger to a contract cannot sue. So this is the statement we might have read when we would have studied, right? You all might have studied contract law in your first semesters or at any other point of time during the preparation. So a stranger to a contract cannot sue. So that is the important line that we usually read. But here it is mentioned as statements regarding consideration. So regarding consideration, the correct statement is stranger to a consideration can sue. Stranger to a consideration can sue. So stranger to a consideration cannot sue is not correct. So the Indian Contract Act under Section 2, Clause D of the Contract Act mentions that consideration is essential for a valid contract, and it must be given at the desire of the promisor. It may be during the past. It need not be adequate to the promise, and a stranger to the contract cannot sue, and a stranger to the consideration can sue. So this is what this statement says. Okay. Ninth question. A contract of life insurance, the performance of which depends upon a future event, falls under the category of contingent contract, contract of indemnity, contract of guarantee, special contract. The correct answer is contract of indemnity. So the contract of indemnity is mentioned in section 124, where it is a contract by which one party promises to save the other from loss caused by the conduct of the promisor or any other person. In case of life insurance, the insurer promises to compensate the nominee or insured legal representatives upon the death of the insured, which is an uncertain future event. The insurer thus indemnifies the insured against the financial loss resulting from death. And contingent contract also sometimes resembles the contract of indemnity or the contract of life insurance, where the life insurance contract is also a contingent contract because the insurer's liability depends on the future uncertain event, the death of the insured person. But the most appropriate answer to the question is contract of indemnity under section 124. Moving ahead to the 10th question. The rule enunciated by section 65 of the Indian Contract Act 1872 is applicable to the agreements which are discovered void by mistake, failure of consideration, impossibility, all of the above. So the correct answer is all of the above. So section 65 deals with obligation of a person who has received advantages under a contract that is discovered to be void to restore it or make compensation for it. So this rule applies to agreements discovered void due to mistake, failure of consideration, or impossibility. So all of the above is the correct answer. Next question. What is the position of a contract when it is caused by mistake of law? Void, voidable, non-voidable, illegal. The correct answer is non-voidable. The Indian Contract Act mentions about mistake of law, so it does not render a contract void or voidable. We have a legal maxim, right? Ignorantia juris is non excusat. Ignorantia juris non excusat. So ignorance of law is a no excuse, so which applies here in this particular provision, where it means that the parties are presumed to know the law. So only a mistake of fact which relates to a fact existing at the time of the contract can make a contract void or voidable. But mistake solely about law and the application to the contract of that particular law, where the contract remains valid and enforceable. So the correct answer is valid. In other terms, we can say it as non-voidable, not voidable. Moving ahead to the 12th question. Rescission of the contract means cancellation of contract. So rescission, to rescind a contract means rescind means to cancel, right? So rescission of a contract means cancellation of a contract. Very easy question. If you know the meaning of rescission, then cancellation or annulment is the meaning. Moving ahead to the next question. Even a student may be treated as an expert under section 45 of the Indian Evidence Act 1872. It was laid down by the Supreme Court. So the act basically does not mention the term student, but it mentions that anyone who has researched or interned over such aspects. So in that stands Kanpur University versus Samir Gupta and others, which was a 1983 case. It mentions that expert opinion and states that when the court has to form an opinion on matters relating to science, art, or skill, the opinion of an expert is relevant. Even a student undergoing training in a specialized field can be considered as an expert. So a student can be an expert uh, while interrogating the witness as an expert evidence can be done under section 45. 14th question. Under section 14 of the Indian Evidence Act 1872, which of the following facts becomes relevant? Fact showing state of mind, yes, it is relevant. Fact showing state of body, it is also relevant. Fact showing state of bodily feelings also is relevant. So all of the above is the correct answer. So section 14 of the Indian Evidence Act deals with relevancy of facts, which shows that showing the state of mind, body, or bodily feelings of a person are relevant. So any mental condition or physical condition or sensation or feelings which can be relevant to a case in determining the evidence of a case can be proved with certain facts. 15. Which one of the following is the correct statement in deciding the question as to the disqualification of a member of the parliament? The president shall act. So does does he need to act according to the opinion of the election commission, Supreme Court, or on the aid and advice of the Council of Ministers, or can the president take a decision on the disqualification of the MP on his own discretion? So he has to get the opinion of the election commission alone. Through none other means, the president can disqualify an MP. He has to ask the opinion of the election commission. So this is mentioned in Article 103, Clause 2. Which one of the following is a directive principle of state policy? Right to education, right to property, right to move Supreme Court to organize village panchayats. So right to education is a fundamental right. Right to property is a legal right. It is not a DPSP. Right to move Supreme Court is a fundamental right as well as a legal right. To organize village panchayats. So this is a Gandhian based doctrine. We call it Gandhian doctrine, right? So organizing village panchayats is a Gandhian doctrine mentioned in the directive principles of state policy. So the state is obliged to create and organize village panchayats. Next question. Civil Procedure Code 1908 is not applicable to which of the following, namely civil matters, revenue matters, service matters, land laws, and local laws. We know that civil matters, civil procedure is applicable. Revenue matters, land laws, and local laws to a certain extent, unless and until the specific law forbids from entertaining civil courts from handling such matters, civil procedure applies. But in service matters, service rules, employment rules, industrial regulation acts, so these kinds of acts and other government orders apply. So civil courts are forbidden from handling service matters. Next question. Article 21A, right to education to all children of the age of 6 to 14 years has been inserted by the Constitution. In which of the following amendments? The correct answer is 86th Amendment Act, the Constitutional 86th Amendment Act. Next one. Which one of the following is a directive principle of state policy? So we have already seen the question to organize village panchayats. Creamy layer rule excluding the well-placed members of a caste from reservation was first laid down in the case of. So creamy layer reservation is with respect to OBC categories where the most economically and socially advantaged section of OBC community were separated as creamy layer, and there is another term called non-creamy layer. So NCLs, where the non-creamy layers of OBC community people get the advantage in reservations. So this was decided in Indira Sahni versus Union of India. Next question. The quorum for meetings of the House of People, Lok Sabha, constitutes. So if there are one of 10 members, 1 out of 10 members of the entire quorum of the Lok Sabha, then the House can conduct its meeting. So there are 245 members currently. out of which in the Rajya Sabha and in the Lok Sabha it is 545, wherein 55 members, if they are present and present in the Lok Sabha session, then the meeting shall be held. 22. A professor of a university who is an eminent jurist is eligible to be appointed as a judge of the High Court, both High Court and Supreme Court, neither in the Supreme Court nor in the High Court, Supreme Court alone. So the answer is option D, Supreme Court alone. So is it not the High Court? Why not High Court? A professor of a university can be in a Supreme Court, but why not a High Court? So that is a question which all the students have right now. So here is the explanation, where Article 124 Clause 3 of the Constitution says one of the qualifications for appointment as a judge of the Supreme Court is that the person must be an eminent jurist, where under Article 217 Clause 2, which is a appointment of High Court judge, which mentions that the eligibility is a citizen of India. He should have been an advocate in a High Court for at least 10 years, or he needs to be a judicial officer in any court for at least 10 years. But family courts judges who are in the family courts, they are not eligible for becoming a High Court judge. So that is by practice and judicial officers rules. 23. In which article of the Constitution is the eligibility for re-election of the president given? Direct question. Article 57. The Constitution, Article 57, which mentions that the eligibility for re-election of the President of India is a person who has held the office of the President for one term is eligible for re-election to the office. So there is no limit on the times of being eligible to be a president. 24. The doctrine of territorial nexus is related with Article 13, Article 211, Article 245, and Article 300. So Article 245 is the answer. Territorial nexus means the interconnection between different states. See, one state enacts a law and it does affect the border areas of another state. So in such circumstances, there is a territorial connection or nexus where the place is enacted and the place in which it applies. So it affects the people there. So that is what is called the territorial nexus, and it is mentioned in Article 240. 25. When the two houses of the parliament differ regarding a bill, then the deadlock is resolved by a joint sitting of two houses. So the president calls for a joint sitting. 26. Outre fois acquit principle is related to double jeopardy. So a person who is convicted or acquitted cannot be tried again for the same cause of action or offense. So that is what it mentions. So it is a provision which is given in the Constitution of India under Article 20, Clause 2, where it states that no person shall be prosecuted and punished for the same offense more than once. So that is what is called as double jeopardy. 27. Here we have an assertion and reasoning question with certain codes given below. So let's read the assertion first. Right to education is a fundamental right. Yes, it is. Our constitution had no provision for education before making right to education a fundamental right. This is wrong. Our constitution had it in the directive principles of state policy earlier under Article 45. Later on, it was changed, brought into fundamental right. So A is true, R is false. 28. After which one of the following Supreme Court decision was the special provision for socially and educationally backward classes introduced by an amendment of the Constitution of India? So we saw the same type of question in this session itself, and I told you that State of Madras versus Champakan Dorairajan was the case with regard to Article 15, Clause 4. Next one. 29. In which case did the Supreme Court direct the government to implement the law against female feticide with full determination? So it is in the case of CEHAT versus Union of India. So the entire complete case name is Center for Inquiry into Health and Allied Teams versus Union of India, which was a 2001 case where strict regulations were implemented with respect to pre-conception and prenatal diagnostic techniques. Prohibition of Sex Selection Act 1994. The statement in order to constitute an offence under the Indian Evidence Act must admit in terms the office offence or at any rate substantially all facts which constitute the offence. The above view was expressed by the Privy Council in which one of the following cases? So the answer is Pakla Narayan Swamy versus Emperor. So these are very rare questions that might be asked. So I don't want you to lose marks without seeing this. So just read through the explanation if you need to know more about this case. 31. A fact is said to be not proved when it is neither proved nor proved. So it is said to be not proved. You don't prove a case, it is said to be not proved. When it is neither proved nor it is disproved. You put a fact in the court of law and that particular fact is not proved by proper evidence and that fact is also not disproved by the defense. So in such circumstances, it is said to be not proved. So in cases where facts are not proved, such accused may be acquitted in cases. 32. The law declared by the Supreme Court of India is binding on all courts within the territory of India, but the Supreme Court is not bound by its own decision was decided by the Supreme Court itself in which case? So very simple. Question is not complicated. So the High Court, District Courts and any other court can take the precedent of the Supreme Court and argue the case, but the Supreme Court cannot by itself. The advocates of the Supreme Court cannot stand by the decision of the Supreme Court as a precedent and argue for the case. They can cite it for the judge's reference, but they cannot argue solely based on such precedents because the Supreme Court can alter its own decision which was taken previously. So this was held in Bengal Immunity Company Limited versus State of Bihar. Next question. Which one of the following is the correct statement? Full faith and credit clause of the Constitution does not apply to. So full faith. So you put your complete full faith, the goodwill, right? So on the public acts, public records, judicial proceedings, but it does not apply to acts of corporations. Next question. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. So section 102, which mentions in the Indian Evidence Act that so the burden of proving a case in a suit or proceeding lies on the person who would fail if no evidence at all were given on the either side. For example, the prosecution says that a particular person is an accused to an offense and he is in the court, he is in the prison under the judicial supervision. Now he has to defend himself that he did not do the crime. So in such circumstances, the burden of proving that he did not do is on the person who is accused of the offense. And the prosecution would argue for the state that he only committed the crime. But it is upon the prosecution to argue that to find out the fact whether he committed it or not. But many a times what happens is the prosecution tries to frame people and they create a notion that the accused did the crime. They want to prove that the accused did the crime. So that is not the way the prosecution should go. The prosecution should try to uh, create complete justice for the person who did the crime and for the person who is accused of the crime. So that we'll talk separately when coming to some topics with respect to present situations. Moving ahead to the next question. Palvinder Kaur versus State of Punjab relates to which of the following? Confession, dying declaration, entries in the books of accounts, relevancy of judgments. So the answer is confession. Palvinder Kaur, confession. Very important one. Just try to remember it. Very important. So what this particular case established was a confession should be complete. It cannot partly reject certain facts and it cannot partly accept certain facts. If you need to accept, you need to accept all the facts and plead guilty. If you do not accept any fact, it should be complete. You don't confess on those facts. So the doctrine of completeness of confession is very important in this particular case. Next question. The principle of promissory estoppel found its roots as an exception to the doctrine of consideration in the law of contract. Yes, obviously. So estoppel is being barred. So what the doctrine says is it prevents a party from going back on the promise even if there is no consideration which is provided. For example, if the promise was intended to create a legal relation between two parties and one of the party acted upon the promise and the other did not act, where it was detrimental and the other party who acted upon the promise suffered due to relying on the promise of the other party, then in such circumstances, the other party needs to act on that promise. In which of the following cases was it held that Section 27 of the Indian Evidence Act 1872 is an exception to Section 24, 25 and 27? So the case is P. Kotaya versus King Emperor. So Section 24, 25 and 26 are related to confessions which are caused by inducement, threat or promise, which are inadmissible in nature, and 25 relates to confessions by police officer, which is inadmissible. Confessions to a police officer, and Section 26 deals with confessions to police officer in police custody, but without the presence of the magistrate. But however, Section 27 provides a limited exception stating so much of such information which it amounts to a confession or not, as relates distinctively to the fact thereby discovered may be proved. So in case such confessions are given to a police officer uh, or to a person in police custody, and upon confessing a fact has been discovered, then based on the facts which are discovered, the part of the statement is admissible. That particular part wherein the fact has been discovered out of the confession given by the accused. So such part of the statement is admissible as an evidence. 38. Which section of the Indian Evidence Act 1872 deals only with civil matters? Direct question. Section 23. (39) A witness who is unable to speak gives his evidence in writing in the open court. Evidence so given shall be deemed to be oral evidence. So section 119 says, if the witness is unable to speak, the evidence may be given in any manner, such as by writing or by signs, and such evidence shall be deemed to be oral evidence subject to cross-examination. 40th question. Which of the following is not mentioned as showing state of mind under section 14 of the Indian Evidence Act? ill will, motive, good faith, negligence. So along with ill will, good faith and negligence, section 14 has many other mentions in as part of state of mind. As we know that section 14 deals about state of mind, state of body, and state of bodily feelings, wherein state of mind alone has certain other aspects like ill will, good faith, negligence. So motive is not mentioned as part of state of mind. Next one. In which one of the following cases did the Supreme Court hold that confession of a co-accused is very weak evidence and no conviction can be based solely on such confession? So there are two accused, one of whom is a co-accused. So the co-accused says that the accused is also, the other accused is also an offender who did the offense. So such confessions are baseless without proper evidence. So there needs to be some evidence which proves that the other offender has also committed an offense. So this was held in Kashmira Singh versus State of Madhya Pradesh. Next one. The principle that possession is prima facie proof of ownership is provided under which section of the Indian Evidence Act? Section 110. So the person who owns it is a proper evidence. The person who possesses it is a proper prima facie evidence of ownership is mentioned in section 110. Rejection of plaint is mentioned under which provisions? Order 7, Rule 11. So rejection of a plaint can be done when the court has no jurisdiction to try the suit is barred by law, the relief claimed is undervalued, and the plaintiff has not paid the prescribed court fee. The suit appears from the statement in the plaint to be barred by any law. The plaint does not disclose a cause of action. The relief claimed is properly valued, but the plaint is written upon a paper which is insufficiently stamped, and the plaintiff fails to supply the requisite stamp paper. So, in such aspects, also rejection of a plaint can be done. So, rejection of a plaint is a decree. So, this is also a common question whether rejection of a plaint is a decree or not. Yes, rejection of a plaint is a decree. Next, 44. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. The definition of the term decree holder is mentioned under which section of Civil Procedure Code? So it is section 2, subsection 3. So we call it as a definition clause, right? 45. Which of the following is not correctly matched? Matrimonial communication, section 122, official communication, section 124, professional communication, section 126, confidential communication with legal advisors, section 127. So confidential communication with legal advisors, they come under professional communications. So the answer is section 126. That is, confidential communications with legal advisors are concepts which come under section 126, not 127. So option D is the incorrect statement. Legitimacy of a child born during a valid marriage is presumed under which provisions of the Indian Evidence Act? Section 115, 114, 112, 113. So even a child born out of concubine relationship is legitimate in the eyes of law, is mentioned in section 112. 47. A barrister is instructed by an attorney or vakil that an important witness is a dacoit. This is a reasonable ground for asking the witness whether he is a dacoit. This illustration is based on which section of the Indian Evidence Act? Section 149. So it allows the court or a party to cross-examine a witness regarding previous convictions. It also states that when a witness is called, reasonable questions may be asked to test the credibility of that witness, including questions about any criminal convictions that could affect their character. So, previous criminal conduct could affect the credibility of the witness. So, it is mentioned in section 149. Next question. Order 23 of the Civil Procedure Code applies to the following. Which of the following? So, withdrawal of suits. Withdrawing a suit by the plaintiff. 49. Section 115 of the Civil Procedure Code provides for the following. We already saw this question earlier. It is revisional jurisdiction. The High Court can call for records of any case which the subordinate court has decided upon. Next question. Last question of this session. Does the summons for service on the defendant can be given to the plaintiff under Order 5 Rule 9A of CPC? So the correct answer is Order 5 Rule 9A. So thus the summons means the court gives the summons copy to the plaintiff to be given to the defendant so that there is a fast trial. The case goes very fast. So there is no delay out of the postal time taken. So that is what is called as dusty summons. The court gives it to the plaintiff to give it to the defendant. Next question and the homework question. Which one of the following cases is on second appeal? Second appeal based cases. Madan Lal versus Balkrishna, Sudhir G. Angur versus M. Sanjeev, Sheldon Singh versus Daria Kanwar, Harshad Chiman Lal Modi versus DLF Universal Limited. The correct answer is Madan Lal versus Balkrishna. So this is with respect to second appeals. So the appeal was against the order passed by the High Court, which went to the Supreme Court. So cases which are challenged based on the substantial question of law could only be sought as a appellate jurisdiction in the Supreme Court. So with that, I end part 13. See you all in the next interactive session of part 14. Until then, watch our other videos. Thank you.